The March 3rd, 2014 Board of Cosmetology is called to order. First, we'll have roll call. State your name and just say present with our new board member.
Kelly Barger, present.
Lisa Murray, present. Earl Smith, present.
Donna Coppinger, present.
Judy McAllister, present.
Rufus Hereford, present.
Pearl Ali, present.
Okay. At this time, we need to take a look at the minutes from the February board meeting. And does anybody have any questions or anything we need to take another look at for the February minutes? I actually do. So,
Yes.
When Denise Lawrence came before us and she asked that we take a vote publicly on whether we were against or for the apprentice program that was made law last year, that was, and we took a vote, and there were 8 board members present. There were 3 board members that voted for and 5 that voted against. I'm pretty sure that's how it went. And all that was omitted from the minutes.
Okay.
There was nothing in the minutes about.
Morning.
Good morning.
Good morning.
Speaking of, so that needs to be added.
Would you like me to add it and present it at the next meeting so you all can look at it and vote at that time? Delay it
Please.
for April?
Yeah, that
Okay.
would be great.
That sounds great.
If we can just take a look at those minutes next month.
Not a problem.
Okay, to appear before the board, Denise Lawrence, you're just in time.
And if I could, for just a quick second, I want to go ahead and also update the fact that we started the meeting at 10 a.m. today for the record, and that was due to the weather. So for those that are here, I thank you very much. And today we don't have Ms. Linda Colley and Courtney Williams are not present, but we are started. And if I could take a quick moment to introduce the newest board member, Ms. Kelly Barger, if you would introduce yourself and let the other board members know that who you represent. And
My name is Kelly Barger. I'm from Knoxville and live there with my husband. I've enjoyed my career in cosmetology for 22 years. Honored to be here, and I look forward to serving alongside you all.
thank you. And if I can just take the moment to remind us that anytime you're speaking, if you can make sure that the mic is on, sometimes if we lean back, it won't pick up on the voice. You can also push down on the speak button below, and it'll pick us up, so we should be in good shape. And Denise, it's all yours. Thank you.
Thank you very much, and I apologize for getting here a few minutes late. I wanted to update everyone a little bit on what went on last week and what legislature, if they make it in today. We're not sure because we just heard all of state. First, with regard to Senate Bill 1893, that's the merger. Both those bills, both the Senate bill is in Senate Commerce tomorrow, and the House bill is in House Government Operations. They actually meet at the same time, so that'll be. We have not had any negative comments about is the chairman of House Government Operations. He is the House sponsor. Watching this one closely to make sure that everything goes through as okay. Another bill that is on notice for House Business and Utility Sub tomorrow at 1:30 as well is this is common for us up there, but sometimes everybody gets confused. All of you are aware of the school authorization issue. Aren't aware of what I'm talking about, I'll be happy to explain that.
I'm not, no.
Okay.
I'm not.
Okay, great. Sometime in the fall, Federal Department of Education is requiring for Title IV student loan funding that each state authorize their cosmetology and barber schools. And we discovered that we didn't have the statutory authority to do that. The board didn't already authorize a school. Schools that are both authorized and accredited are those schools that usually try to draw down the federal funds. Students going to those schools typically apply for student loans, and so this became an issue. We worked with trying to come to some resolution of this issue. We knew that there was going to have to be some sort of legislation. This bill is the vehicle for that legislation. However, we have drafted some language. What would happen is, whether we use this bill or a combination of other bills, it would give authorized schools for a period of time until such time that a better method can be worked out. THEC, typically Tennessee Higher Education authorizer for all educational institutions. There's a lot of thing that's important to remember is this bill, though it is scheduled for subcommittee tomorrow, using a series of bills. So this is what we did last week, and I wanted to give you Senate Bill 760 by Senator Johnson is another caption bill. We think this bill may be the vehicle that barber schools, and then we'll have to find an education. That one, the Senate sponsor at the moment is Chairman Gresham, who's the House companion. We don't have confirmation from Representative Holt that he probably end up having two vehicles to handle the authorization issue. And I know this is very important to school owners. So that's all about. Oh, I'm not really sure if these other bills might mention. The Senate Bill 1734 is the Tennessee Streaming Video Act. I mentioned this one before. Are all boards and commissions to video stream their meetings. That all of the different agencies within state government. It's specific applies to Commerce and Insurance because we have the largest number of regulatory boards, and Health because they have a good number of regulatory boards. Well, I think that there may be some issues with infrastructure, which I don't think is specific to our situation, but maybe. Senate Bill 2053 was a caption bill that, no, I'm sorry. All agencies study whether or not apprenticeships in the different professions are viable. Is the okay, yes. Yeah, I was looking for that one. Okay. Yes. Senate Bill 2487, which allows a cosmetologist to perform work outside the shop. I think this might be something that y'all are familiar with that came up. Us who styles hair. So that one has not been put on notice yet, but it's been introduced. And I believe lives in Franklin, and she Senate Bill 1938 was in House Business and Utility Sub. That bill did not have enough support to come out of Business and Utility Sub and was in order to get it done, but it's something that both Chairman Johnson.
I have one,
Yes,
or two, or I don't know how many I have. Let's see, I was gonna ask you, you said the Senate bill, I didn't write down the Senate bill number, but House Bill 2416, is that the same one that you were talking about?
Yes, it's Senate Bill 2487. That's to perform work outside of the cosmetology.
Right, it says, I read it, it says to style hair and apply makeup
Right.
outside of a shop if certain regulations or requirements are satisfied,
Yes, ma'am.
which is so vague to me, I wasn't sure what that even meant, but. And also, so the Senate Bill 1938, you said it's deferred to summer study, so it will come back up next year, next session, right?
Actually, it won't because we're in the second year of the session. It would have to be reintroduced, or another bill would have to be introduced.
Oh,
So,
really? For the appeal?
yes, for the repeal, yes.
Oh, I did not know that. Also, last month, you mentioned that there might be a bill concerning continuing education or an amendment to a bill concerning continuing education. Has that happened?
I don't remember that. It hasn't.
Okay.
And I apologize, I don't remember that.
Any other questions? Thank you, Ms. Lawrence.
Thank you so much.
Okay, next to appear before the board, Damon Romano.
funny.
Thank you.
All weekend at the basketball tournament, my wife was saying I replaced Wayne Pugh, and my job is to supervise.
The purpose of my being here is not to tell anybody something, puzzle anybody, or tell you how to do the job, but I am going around systematically, or I'm being sent around fairly all of the regulatory boards and commissions, of which there are approximately 24, in order to make sure that, because all on the same page, and that any misconceptions I have a tendency to talk plenty loud but a little bit fast, and so I will appreciate you all for stopping me and asking any questions you may have, and especially to our new member. If there's any of this that's not familiar to you at all, please don't hesitate to throw up a hand, and I'll wherever I am. There are two laws, broadly speaking, that together comprise the Sunshine Law as we know it. The Open Records Act, and the second is the Public Meetings Act. The Open Records Act is something I'm going to touch on very briefly right here at the beginning. As a matter of course, this is something that is dealt with by Director Gamusio and her capable staff. It deals with things like Freedom of Information Act requests, any kind of records or documents pertaining to y'all's business. If somebody wants to find out what the resolution of a particular disciplinary matter was that happened at a meeting 2 or 6 months ago, they would make a records request through staff, and that's how that would be handled. Excuse me. So generally speaking, broadly speaking, if the board conducts a piece of business and it's recorded, and almost all of it is, it's fairly well subject to the Open Records Act. What is included specifically? According to the Tennessee Code, public records or state records includes all documents, papers, letters, maps, books, photographs, microfilms, electronic data processing, files, and output, films, sound recording, and if that's not enough, all other material, regardless of physical form or characteristics, etc. And so the idea there is everything, absolutely everything that is produced from out of the business of the Cosmo Board is all subject to and covered by and part of that Open Records Act. Excuse me. Now, it's the stuff that's before you, but not the devices. So if somebody were to make an open records request of you, it would be, for example, everything that's on your iPad right now, but not the iPad itself. Okay? And that's pretty much all we will say this morning about the Open Records Act. And so we'll get into the bulk of what is pertinent to you all and how you conduct meetings and how you do your job, and that's the Public Meetings Act. There are about 4 big issues that we cover with public meetings, or questions broadly that I will answer or attempt to address for you this morning. First, what is the Public Meetings Act? Second, what's a meeting and what's not a meeting? And we'll try and put some fences around that so we have a good idea about that. Once we know what a meeting is, what are you all required to do, or what are you prevented from doing, prohibited from doing under that act in a meeting? Those requirements are about 4 broadly: notice, the agenda, which is really just part of the notice, public presence, and minutes. You'll find that once we cover, ladies and gentlemen, what a meeting is and what notice is, those two things comprise about 90% of everything that you all deal with on a day-to-day basis and that you need to know in order to be able to do. Finally, the fourth and final question this morning, what happens if the board violates the Public Meetings Act? And the answer, very simply in a word, is nullity. What the state law is going to say and what the courts are going to say is that if there is a violation, it is as though it never happened. Okay? We're not going to wait to back up for somebody to sue the board and come up with some court fight. We're just going to behave as though you never did it. Okay? If there's a finding that if the court were to find later there was a violation, we're going to go back to the day it took place and say it never happened. Okay. All right. I mentioned minutes as one of the four things, the proper keeping and, if necessary, the promulgation of the minutes that you're required to keep. That's something that staff takes care of for you. By the way, that nullity for a violation, that flows down to licensees. And there is a particular action that the board takes, and it is found later to be in violation of the Sunshine Law, and then we say it's as though it never happened. Well, what if you took a disciplinary action in that meeting that never happened because it violated the Sunshine Law? It was as though that discipline never took place. And so with the best of intentions, you could wind up not doing what you thought you were doing when you were trying to prevent something bad from happening or promote something good. And I'll talk a little bit more about that later. What is the Public Meetings Act then, to our first question? The Tennessee Code says, the General Assembly hereby declares it to be the policy of the state that the formation of public policy, which would include things like your rules and regulations, adopting new rules, amending existing rules, and all decisions, pretty much everything else you do, any kind of discipline, granting of licenses, revocation of licenses, all of that is public business and shall not be conducted in secret. Next part of the bill, or the law, says that it shall not be construed to limit any of the rights and privileges contained in the Tennessee Constitution. That's referring there to the free speech section of the Tennessee Constitution, meaning, in other words, you're all still citizens of the state. Right? And so you're, in the exercise of your duties, we can't prevent you from exercising your free speech as citizens. The way to read those together, though, is to say, well, look, it's not the intention of the state legislature to tell you what you can and can't say. It is the intention of the state legislature to explain to you that when you are serving in your official capacity as a member of this board, that everything you say ought to be on the record and out in the sunshine. The act is remedial in nature. That is legalese for we can't fix a problem until after one has already come up. So because we can't fix it until after something unfortunate has happened, after there's been a violation of the Sunshine Law, the courts are going to construe this very, very broadly in favor of the public. And we will see repeatedly a lot of language both in the statute and coming out of the Tennessee Courts of Appeals and the Tennessee Supreme Court saying that we want everything, if there is any doubt in anybody's mind, be very above board about it. A moment ago, I mentioned all of your policies and decisions are public business. The next section of the law says, quote, all meetings of any government body are declared to be public meetings open to the public at all times, except as provided by the Constitution of Tennessee. That is one very narrow exception called the executive session exception, and we'll talk about that more in a few minutes. So before we said all of your policies and decisions are public business, now we're also telling you that all of your meetings are public business. It absolutely applies to the Cosmetology Board. A governing body means the members of any public body that have 2 or more members, which is us. If you have the authority to make decisions or make recommendations about decisions to a public body, then you are a governing body and you're covered. What this language and this part of the law is saying is, look, we're picking up committees and subcommittees as well. In the past, there was a problem where we said, okay, the whole meeting of the board, the plenary board, has to have everything out in the sunshine. But we could do a committee meeting or a subcommittee meeting behind closed doors, and that would be okay. No, you can't get away from that. The Tennessee Supreme Court said in 1976, the legislature intended to include any board, commission, committee, agency, authority, or any other body by whatever name. So everything's covered. Again, that very broad, expansive language. Everything's a meeting. Are there any exceptions to that? Are there any kind of fences or boundaries that we can put around that? And there are. Let's talk briefly then about what is not a meeting. A meeting does not include any on-site inspection. Okay, so when the investigator goes out, periodic regular inspection of a shop, that's not a meeting. What else is not a meeting? And here's where it gets a little bit sticky. A meeting does not include any chance meeting of 2 or more members of the board. So if y'all happen to run into each other at the Piggly Wiggly or at church on Sunday, that's not a meeting. However, then you're prohibited from speaking about board business at that time. The law says no such chance meetings or informal assemblages can be used to decide of the requirements of the act. So this is the spirit of the law clause to go along with all the letter of the law stuff. I promise here towards the beginning not to bury you in legalese law cases, but I'm a law student, and so I can't help but think that way. It's like wolves, and then you can only talk to wolves. There is a case that I want to mention to you, 1 or 2 this morning, and the first one is there was the town of Kingston Springs, which y'all may be familiar with. They wanted to annex some unincorporated county land that was nearby. And though they took the full vote on whether or not to do the annexation, they did it at a full meeting of the board, out in the sunshine, on the record, under the gavel, as you all are sitting here today. However, when they were parsing out and deciding exactly which blocks and streets they were going to annex, they did that behind closed doors, off the record. And some of those people who got annexed were not real happy about being annexed, as you might imagine, because now they're liable to some city taxes that they weren't before. And so they sued. And the court said that's a violation of the Sunshine Law. You can't do the substantive part of it behind closed doors and then just kind of rubber stamp the thing in the full meeting. And what effect did that have? It was as though they never did the annexation. And as you might imagine, this took a couple of years to work through the court system before they finally came down to this decision. So all of those taxes that the city had collected for those 6 or 8 months had to then be refunded back to those people. And it put the city in quite a bind, in a much worse off position than they would have been if they had not done the annexation in the first place. So there are real consequences to all of this. There have been cases on both sides that say if there has been, where a board or a commission has been sued and saying that there was a violation of the Sunshine Law, something was not done as it ought to have been done, And there have been some cases where the Board or Commission has lost and the court said there was a violation. And there have been some cases where the Board or Commission won and they said, look, there was no violation of the Sunshine Law, or there was, but they fixed it later, and so no harm, no foul. I would like to suggest to you, however, that that is not a tightrope y'all want to be walking. I would like to submit to you that if you get sued, you've already lost. You see, because then you're sinking massive staff time and resources that would otherwise be going to the running the business of the board. Your own time having to come down to Nashville and get deposed and get subpoenaed and give testimony in court. A lot more than just a big inconvenience. Excuse me. So our behavior, certainly not to suggest that it hasn't always been, but ought to always be such as to avoid any appearance of impropriety, because if we raise a red flag, then we're going to get sued, and that's, at that point, as I said, I think you've already lost. What's not a meeting? We have an opinion from the Tennessee Attorney General that says 2 or more members of a public body can share a meal together in which public business is conducted. But such discussion should not constitute deliberations. Folks, if you are able to predict ahead of time what some judge might say later on about whether your discussion over lunch about board business was just a discussion or if it rises to the level of deliberations, you're smarter than I am. And again, that gets to that fine line that we probably don't want to get near. So if you run into each other, at the have lunch, play golf together, go to church together, have a party. But you ought not to discuss, deliberate, debate, or otherwise decide about board business. Lunch breaks, restroom breaks, smoke breaks. If you have a recess between a morning and an afternoon session, if you have a multi-day meeting and you take a recess at 4:30 or 5 o'clock at night and you're in recess until the second day of the meeting begins the next morning, all of that is not a meeting for the purposes of the Sunshine Law. But then, of course, you're forbidden from talking about board business. What kind of meetings are meetings? Regular meetings, special meetings. By the way, that's going to include any emergency meetings that you all decide to conduct. If you've ever had an emergency meeting, you know that it still takes staff 2 or 3 weeks to put notice out to the public because that's covered and it still has to be available to the public. All right. A few minutes ago I mentioned an exception, that there is one exception to the Public Meetings Act, and that's the executive session exception. What is the executive session? It is when one or more board members meets with the board's attorney, Mr. Herndon, and when the board is either being sued or under threat of being sued, or you believe you might get sued over it, and you are there to ask your attorney, your board attorney, Mr. Herndon, questions related to that legal matter, that suit or potential suit. Okay? In other words, the executive session is there for you to go behind closed doors and get sound legal advice from your very competent and very handsome board attorney. There are 2 things to remember about that. So if you get picked up on a DUI after a wild night of Cosmo board partying, he's not going to be able to help you with that. But you are able to go to him in an individual capacity. I took some action as a member of the Cosmo board in my capacity. Now somebody's upset about that. What can I do about that, or how do I diffuse that? That kind of a question is a perfect question for your board counsel. How far does the Public Meetings Act go? I mean, I've talked this morning about broad language, expansive language, how broadly the courts and the state legislature mean this to be interpreted. Let me tell you how far it goes. In Maury County, there was a Civil Service Commission. There still is a Civil Service Commission. And the Maury County Civil Service Commission was tasked with providing or conducting sort of first-level interviews, right, to vet candidates. And this list of vetted candidates would be a list over here, and from that probably public meetings and subject to the public. That ought to give you a very clear idea of the kind of seriousness with which the state legislature takes all this. They intend that being very open and very above board about all of this trumps any kind of efficiency concerns and trumps a lot of. So how about communications between and amongst yourselves? If one of you, Ms. Smith, decides you want to email the chair and say, here's a news article, for example, that's related to our profession, that's fine, you can do that. If you say, Madam Chair, there's an issue that is very important to me, I'd like to have it included on the next agenda, that's fine, you can do that. But if you say, here's an issue that's very important to me, here's a news article about one of our licensees, and I read about it, you know, in the Knoxville paper that says that one of our licensees disciplining this person or revoking their license, no. Now you've crossed the line. Now you're engaging in debate, deliberation, you're offering your opinion as you would offer it at a meeting. That's where we say, let's put the brakes on and let's not talk about that until we get under the gavel on the record in a regular meeting. Again, it's a little bit different when you're trying to communicate with your board counsel. If you say, I have a legal question about the consequences of something I've done, you know, maybe on to speak to a charity group or you know, give a talk at a high school or something, trying to you know, convince about the business as a career. And you're doing this then in your official capacity as a member of the board. Well, you're supposed to have the sort of blessing of the board, as it were, the authority given to you from the board that was taken in a vote at a meeting to do that. Well, if you don't, is that a problem? That's a good question for your board counsel, and you can email him, call him on the phone, and all of that is fine, but not, again, your personal legal business. What then if you undertake to email one another or communicate with one another outside of the bounds of a meeting? My strong recommendation to you, ladies and gentlemen, is just don't. If you happen to go to church together, two of you, and you say, you know, or whatever it happens to be, if you run into each other in the grocery, and don't these potatoes look wilted and nasty? And by the way, I'm real concerned that is potentially going to come before us. That's a real. Talked about the chance meeting if you happen to run into each other. Well, if one of you picks up the phone to call another member, there's nothing chance about that. You act, the courts are going to say, and even if it's completely innocent. And the school play the other week, and that was real precious, and that was nice. But what's it going to look like to the outside world? Or they get to figure out that the contents of that email were perfectly innocent and fine, the first thing that they're going to discover is that a couple of the members of the Cosmo board have been emailing back and forth to each other outside of a meeting, and nobody knows what was said. And so it raises that red flag. It raises that appearance of impropriety. And that's something that we ought always to avoid. What about electronic attendance? Today we've had some bad weather. We've got 2 of our 9 members that couldn't be here with us today that are missing. So that you can include them by telephone, and they can just be here in the sky. That's fine. What you have to do then is that you're not allowed to do a voice vote. You can't, all in favor say aye. That's off the table at that point. If anybody's coming in by telephone, then you need to drop down to the roll call vote where each person gives their name and votes yes or no. Why? Because the public has a right to know who's voting how. And if there is a member of the board that's not physically present and the public can't lay eyes on them and see how they're voting, then we need to do our votes in such a way as that the public knows what we're about. Everything then has to be roll call votes. If there are enough of you to make a quorum without the missing members in the situation we have here this morning, that's fine. You just go on business as usual, and you can choose to include or not. If the in-person number of members is not enough to make a quorum, can we still go forward with our meeting if we have enough people by telephone? And the answer is yes, we can. At that point, the chair or the acting chair would have to adopt and promulgate what's called a statement of necessity. Just a simple statement. You can either write it down, it'll be put in the minutes, or you can just speak it onto the record that says, look, we understand that this is not the normal way of doing things. We do not have a quorum here in person. However, we're here to serve the public. And the public need is such that we have a necessity to go forward with our meeting regardless, and we'll make do the best we can. And once you have that statement of necessity, then you're free to proceed as normal. That kind of a case, and it's sort of a moralistic story, but it's it's not the Brothers Grimm. So I'll tell you. From that decision, the court said the act, meaning the Public Meetings Act, is to be construed most favorably to the public. That's what we're here to do, is protect the public. By the way, the Public Meetings Act, it came up at another board meeting that I gave last week. What about the state legislature? Are they subject to this Public Meetings Act, where everything they have to do is on? Why? Well, because if they do something, and we as the citizens of the state, a way to get rid of them. We can vote them out of office. You all here have not been elected. And so the Public Meetings Act and the Open Records Act and all these sunshine laws are there to have a throat so that the public, if they're upset, can put their hands around that throat and shake back and forth a little bit and have some accountability. Okay. We see that breadth of language. In this Shelby County Board of Commissioners, there was the Shelby County Board of Commissioners, and one of their long-serving members passed away in office. It was very sad. It so happened that this gentleman represented a very heavily minority district of others of the commissioners got together, they were friendly, and so they started telephoning one another back and forth to say, we have this heavily minority district be adequately represented. And so we need to make sure that this gentleman nominated you, would you be willing to serve? And he said, yes, I would. And so then the whole county commission got together. They said, we've had this unfortunate vacancy, condolences to him. I have a motion, and this person's name was put up, Mr. So-and-so, and they said, okay, is there any discussion? There's no discussion. Let's take a vote. Unanimous, the guy goes in and he takes his seat at the next meeting. And for the next 6 or 8 months, he does business as normal. And by all accounts, provides a stellar service to the public. And then somebody says, well, now hang on a second, that seemed to go kind of fast. Oh, first reading, second reading, third reading, any of that, and he just gets on the board. And that looks a little fishy. Something happened that we didn't see. All we saw at the meeting was, there's a vacancy, here's a name, all in favor say aye, the vacancy's filled, and now we're moving on. And so they sued. Talked about nullity, as though it never happened. And so it was as though that gentleman had never been appointed to fill that vacancy. And so every vote of the county commission that he participated in also went away. Every committee or subcommittee that he sat on, all of those meetings were tainted. And all of the good work that he had done evaporated. And so the whole county commission, you know, Shelby County's not a small place. The entire county government was set back 6, 8, 10 months. Because with the best of intentions, we said, well, we can do this behind closed doors because we've got to do it fast. And we're going to find the courts being very clear on this and saying fast is not nearly as important as right. All right, I have been awfully heavy, kind of a downer for a Monday morning, isn't it? Public attendance. You are required to allow the public to attend your meetings. You are not, however, required to have business to do. You've been charged by the governor and by the state legislature to perform a regulatory or administrative role, and you have business to do, and you need to get through it. You may allow the public to speak if you desire, but you may also place reasonable limits on that. If you say, folks, this is a real important issue, and we want to hear from you, our licensees, about this, or from, but we have a full agenda today, we can only allow 30 minutes maximum, and 60 seconds apiece. Allow the public to participate in your meetings at your will. You are only required to allow them to observe and be present. But you are required to allow them to observe and be present. So now let's talk about notice. I said before, once we figure out what a meeting is and what a meeting is not, and what you can do at a meeting and what you shouldn't do at a meeting, and so on. Once we've figured out what a meeting is and what notice is, we will have covered everything that we need to cover today. There are 3 components to notice: the contents, the timing. Broadly speaking, you have to give contents notice. You have to let people have a reasonably accurate idea of what it is you're going to be talking about at that meeting. Now, I say reasonably accurate. It's not carved in stone, right? It's not once you've published the agenda, now it's like the 10 Commandments, and never more shall it ever be changed or altered. At the end of most agendas, there's an item that says new business. Well, by definition, we don't know what that is beforehand. So that gives us a clue, is that it's a little bit fluid. You're not, some commissioners or board members feel as though they are bound with heavy chains to adhere to the letter of their agenda. It's not so. You have some flexibility. The point of having notice, and by the way, we're not tied to the agenda format. There's nothing in the law that says you have to do an agenda. It just so happens that this board and other boards and commissions like it have chosen the agenda format in order to do notice. So it's a conventional normalcy now, and that's fine. The idea is to give any given member of the public notice that, well, if there's an issue that I'm particularly interested in, I need to know that they're going to be talking about it that day at that meeting so I can show up and hear what they're doing and how it might affect me. Next is time. If you give a notice that's perfectly accurate and you publish it 40 minutes before the meeting, what good does that do? All right. The rule of thumb, by the way, is about 7 to 10 days. The courts will say if you publish notice 7 to 10 days before the actual meeting, then you're fine. As a matter of fact, though, if you were to look at the Department of Commerce and Insurance website or the Cosmo Board's website, you'd see the agenda for all of your meetings for 2014 published. So we've got you going a year in advance now, and that's thanks again to your staff. Covered on timing. Finally, location. If you make a brilliant notice that has flowers and rainbows and tells the public everything, and you publish it a year in advance, and the only place you publish it is in the boiler room in the basement of the building, what good does that do? Because nobody then has seen. The Attorney General says typically there are 3 usual normal methods of doing that. First, by the internet. Secondly, by the newspaper. You might have heard that phrase, newspaper of general circulation. We don't do that anymore because we have this wonderful invention called the internet, and that's much broader. And bill posting, finally. Just stapling up a poster somewhere, which, by the way, we do before each of your meetings in the lobby of this building, to direct people to the correct meeting room so that nobody can say after the fact, well, it's a big building and I got lost and so I didn't see the meeting and therefore it's a violation of the Sunshine Law. You'll find, I said internet, that your agenda is posted on the Department of Commerce and Insurance website, on your Cosmo Board website. There is also a system whereby a member of the public can sign up and they can have an email shot out to them when something that is important to them is going to be discussed or when the next meeting comes. People have notice. That contents, timing, location is what the courts call an all the facts and circumstances, meaning you have to do them all. You can't give notice a year ahead of time and then skimp on the details that are in the notice. It's everything. Wrap up. The Public Meetings Act is designed first and foremost to protect the public, make sure all board business is conducted in a way that is accessible to the public. It absolutely applies to the Cosmo Board, both collectively and to you in your individual capacities as a board member. Anytime that you are together, which is to say, if you are talking about board business in your mirror at home by yourself, then you're not covered by the Sunshine Law. Anything else has to be in a properly noticed meeting. And again, the only exception to that is your executive session, where you can get on the phone with or shoot an email to or meet in person with your board counsel, Mr. Herndon. And at that point, though, again, you're not supposed to discuss board business. If you say, we are thinking about amending a regulation, we are thinking about what are the legal consequences of that, because it's a hot issue for some reason, he can say, here's my sound, considered legal advice or opinion on that matter. And then if you start, and that's okay, but then if you start cross-talking and say, well, based on that advice, that legal advice, I think such and so. No. At that point, you need to stop, go back into the meeting room, get back under the gavel, and have those opinion discussions on the record. If you violate the law, any violative acts are void. I wanted to mention one last, I promise, the last one, court case to you. This is a transcript of the court case. It came down out of the Tennessee Court of Appeals in Knoxville, but it's there was a board or commission, in a nutshell, that was found to have violated the aha, now we have something else. Some member of the public sued the board and won and said there was a violation. Oh, by the way, that member of the public had to hire an attorney in order to and at first, the trial court said, no, you don't get attorney's fees. What you get is what you wanted. You nullified the action of the board. And the public person who was the court said, no, you have to give them their attorney's fees. And then and bounced it down to the next court. And the next court said, okay, but $70,000 is excessive and unreasonable, so we're going to cut it in half. Now it's only about $35,000 or $40,000. And they appealed again, and it went back up again, and the Tennessee Court of Appeals finally said, no, if it costs them $70,000 in attorney's fees, you got to give them the whole $70,000 in attorney's fees. So it bounced back and forth. More court cost for the board, more time for the staff. And where does that money come from? Act adversely your ability to do your job, to send out investigators. Now we're finding out, at least as of 2 weeks ago, there's real money. Let's be above board about this. The last thing that I would say, and I have it in my notes here, the best way to protect yourself and to protect the decisions that you make, because you all are acting in the public interest, to make sure that the profession is done in a safe way. And so we want to allow you to be able to do your jobs. We don't want you to be muzzled. Excuse me. I have in my notes here, I said the best way to protect yourself in your decisions is to be paranoid. Maybe paranoia is too strong of a word, but certainly scrupulously conscious and diligent. Are there any questions at this point?
Yes. Up until last year, for a few years, Board Member Smith and myself, we were allowed to meet with the producer of the continuing education workshop in Memphis, and then starting last year, we couldn't both meet with her. And can I get a clarification as to why that no longer can take place as it relates to what you said earlier?
Mm-hmm. For exactly that reason. That's a excellent question, and a very similar question came 3 weeks ago in front of another board where they're having
Correct.
and you're not in a gavelled-in meeting?
Correct.
Okay. But you're talking about board business that's going to affect your licensees.
But
If it's a continuing ed workshop, so you're talking about, I guess, the content of that workshop?
the content, it's feedback on content, yes. That's what we discussed.
We're going to say that that's board business. I mean, that's why you're there. You know, you wouldn't be there just to have a social chat and have there to do business on behalf of the board. And so there's two or more of you there together, members of the board. That's something that needs to be campus and allow the public an opportunity to attend. Because what we're talking about is something, if you think about it, you're talking about material that's going to go into a continuing ed presentation that's going to, and your licensees are going to come, hopefully, to that continuing ed that information, and they're going to behave accordingly, which in turn is going to affect the public, the citizens of the state. And so that's absolutely something that needs to be on the record. And part of the reason that you may have been able to do it before, but I don't want you doing it anymore, is because in the last couple of years, and part of what's associated with me going around and giving a presentation like this to all the boards and commissions at the same time, is because there have been some, not changes, but clarifications in the law as the courts, Tennessee, out with a couple of newer cases, rulings on these issues, as the Tennessee Attorney intention in the law. What was cloudy has now been made clear, and so we're harder of a line. They want to make sure that they avoid any appearance of it, because you know what you're talking about, but the public doesn't know. You could be bad-mouthing licensees. I don't think you would, but you could be out there bad-mouthing licensees, or discussing all manner of stuff. The higher question is, we need to, do we know about it or not? What are they saying? Does that answer your question?
Sure, thank you.
Sir,
What do you think that the Sunshine Law does to the efficiency of any operation?
And
let me ask you one more.
Okay.
What would George Washington have thought about all these laws that we have right now?
That's a good question, and question leads me to believe that my personal opinion would probably agree with yours, but I'm not here to give my personal opinion. To answer your first question, though, effect on efficiency, your implication almost certainly affects efficiency. It almost certainly negatively affects efficiency, because instead of being able to pick up the phone, if you're a school owner, I understand you're a school owner, required to give certain lessons, but there's been a change in the practice. I'm not able to change how I teach unless we go through amending some. But the changes themselves would strongly impact your licensees and therefore the public. The state legislature and the courts, in fact, I didn't read it to you because I didn't. But they've been very clear about the idea that efficient. All of this on the record and having the public hear about it. It is, I understand, but that's why we're here. I have one other question that I would like to pose to you, lastly. We all know what we need to do. Let's get together over the phone, or let's just have a little meeting about what we need to do. And then we will come back later into our regular meeting and get on the record and get under the gavel and just repeat all of that verbatim and go through it, and then we can knock it out real fast, back some of our efficiency. Is that okay? Is that legal? And it turns out there was a case where the court said, well, they violated the Sunshine Law by meeting behind closed doors, but they came back later and had the same conversation. And so the error that they had by violating, they fixed it because they did eventually have that discussion and they took all of their votes about it on the record. And then this right back in right after them and passed the law, changed the law, and said no. Because they came back and they said that's even worse. Because now not only are you going behind closed doors and violating, now you're trying to cover it up by having sort of a rubber stamp kind of a version of the same thing on the record. And that's absolutely not going to work. That concludes my remarks this morning. Folks, I appreciate your time this morning. Thank you so much for allowing me to spend some time with you. If you have any other questions, of course, you can address them to your executive director, Ms. Guscio, or your counsel, Mr. Herndon, or if you just love my smiling face so much that you can't get enough of me, I'll be happy to come back and address anything else, any other concerns you might have. Thank you.
Thank you, Mr. Romano. Thank you. That's everything and more we ever needed to know about the Sunshine Law.
Keep you busy for me.
Okay, next to appear before the board, Robert Christian.
And if I could take a quick moment, we're going to move pretty fast. We've been told that the building is closing.
Oh,
So
okay.
we're going to go through all of our urgent matters that are business. And the two schools that were going to appear, I went ahead and told them to be on the cell phone in case we had questions. So we will definitely, because they're ready to reopen. If I could, Madam Chair, I have Mike Agee is wanting a few minutes of the board's time. If we'll make him quick, and it'll be up to you to decide. He wants to give us an update on the Tennessee Beauty Association so that he doesn't have to wait any longer, if you're okay with that, and then we'll move as quickly as we can.
Okay, that's
that
fine.
okay?
That's fine. Mike Agee. Come on down.
Thank you. I will be very quick. Mike Agee, represent Tennessee Beauty Association of Beauty Professionals. Denise gave you a very good that is moving through. She talked to you about state authorization. I'll make one comment because of your question on House Bill 1938. I'll go finish the rulemaking process, so we'll have the details. We do expect to discuss this issue again next year. On a related topic that really doesn't directly affect you all, though, Representative Parkinson has now
Oh, okay. Okay.
Representative Parkinson's bills, 1980 was the one he told me was looking at some continuing education on. I asked him about it this week. He has done nothing. It's not moved, and that's all I have. Thank you.
Thank
for your
you.
time.
Thanks.
Okay, next on your iPads, we are on page 41. Well, no, I just touched something. The very first school, Mr. Robert and Susan Christian, again, they did come in town, but decided to, and I agree, just stay and let us call them if we've got any questions. They closed their school down at the end of January for the relocation, and as the weather hit them where they were going to move and come at the February meeting to present a plan, the pipes burst. So they've gone to Plan B for this building and presented this new floor plan. So you have in front of you also a description of the physical information on the building as well as the map, and I think it also details it pretty good as far as the square footage being 3,456 square feet. They are moving from Maryville to Von Bonor. So their students have not been in class since the end of January. They had hoped it'd be a quick, smooth, and then with the pipes bursting, they've gone to this other location.
They're asking that we approve the change of location?
That's exactly right. They're asking us to approve the change of location. We would send a board member to that location as well as a inspector, if the board approves.
I make a motion, we approve the request.
I second. Motion made by Mr. Hereford that we approve the request, seconded by Ms. Walker Ali. All in favor, say aye.
Aye.
All against, all opposed, and motion carries.
Next is Joyce Meadows with Georgia Career Institute. She too came in and stayed the night and is available if we've got questions. They're also relocating, and the information is provided on your iPads as well as the new floor plan. Their floor plan is very detailed, not quite as easy to see, unfortunately, on the iPads, but they're doing the same thing. They're asking for an inspector to look at the facility and see if they can be approved for a relocation.
Your motion?
I make the motion, Madam Chairman.
All righty. Motion made by Mr. Hereford,
I second.
seconded by Ms. Smith. All in favor that we accept and send out an inspector to this location, say aye.
Aye.
All opposed? Ayes carried.
Next on our board business is, for 2014, we need to vote on adopting Robert's Rule of Order. If I could have a motion to adopt, and that's how we carry on business during the board meetings, that would be what we will choose to do during 2014 meetings.
Make the motion, we adopt Robert's Rules of Order.
A motion made by Ms. McAllister that we adopt the Robert's Rules of Order. Is there a second?
Second.
Seconded by Ms. Murray. All in favor, say aye.
Aye.
All opposed? Ayes carry.
To make sure that everyone is present, at the next meeting, we will vote, we're supposed to do it annually for a chair and vice chair, so we're going to delay that for the next meeting. Next on your iPads are our application for examinations. We only have 2 individuals, Jessica Williams and Tabitha King, have felonies and have provided the necessary disclosure from the student and letter of recommendation. We need a motion to approve. Both of these will be getting consent orders and have to sign them before we can approve them.
Make the motion to approve.
I second. Ms. McAllister made the motion to approve with a signed agreed order, seconded by Ms. Walker Ali. All in favor, say aye.
Aye.
All opposed? Motion carries.
Next on your iPads is an extension from Ms. Julia Maroon. She's asking for an extension on her continuing education instructor license. It expired on February 28th. She's provided a letter explaining her father's illness and then recent passing. If she's asking if we would approve her continuing education for the April session since she was not able to attend timely.
There's an April seminar in Memphis.
It's with Expertise, and I don't remember their location, if the April one is Memphis or not. It's available on our website, but it is April 14th and 15th, if I'm not mistaken. That is the one that she's wanting to attend. The February one was with Expertise as well, so she'd be attending the April one. The Memphis is actually in June 8th or 9th, if I'm not mistaken.
The one at the University of
Correct.
Memphis is.
Correct.
Yeah. In this correspondence, it says April 12th through 13th in Memphis, so.
That would be with Expertise then, that's correct.
Okay.
Make the motion that we extend.
A second.
A motion made by Ms. McAllister that we extend her continuing education to the April 12th seminar in Memphis, seconded by Ms. Murray. All in favor, say aye.
Aye.
All opposed? Motion carries.
We are on page 24 of your iPads, and this is a change in name. Ms. Quanah Harris is with Last Minute Cuts She's requesting the school change its name to Last Minute Cuts School of Barbering and Cosmetology, provided as the application she's completed. I was able to reach her Friday on the phone. The wrong form has been filled out. She's filled out a shop application form, so we won't actually send the license until she fills the correct one. But she's paid for the fee, and the letter that she's provided explains that she needs it to say Barbering and Cosmetology School for her consistency with her NACAS accreditation. So she's simply changing the ending of the name.
I move that we approve the name change.
I second.
Motion made by Ms. Walker Ali, seconded by Ms. McAllister, that we approve the name change. All in favor, say aye.
Aye.
All opposed? Motion carries.
This is the part where we're going to go fast. As you all know, with the field trips, you've got 2 spreadsheets in front of you. Normally, I go through and read each one of them. If you could glance through them all, a few are for dates that have passed simply because they came right after the last meeting in February. Let me know if there are any you have questions and concerns about. And on your iPads, you can expand it so it's a little bit easier to read, so feel free to do that. And then at the end, we'll take a motion unless you've got any questions or ones that need to be amended. And starting with next month, the new forms will be used for the field trips. I think that'll be very helpful.
Any discussion on the field trips? Go to the one in Las Vegas. Do I hear a motion?
I make the motion to approve.
Motion made by Ms. McAllister to approve the field trip request. Do I hear a second?
Second.
Seconded by Ms. Murray. All in favor, say aye.
Aye.
All opposed? Motion carries.
We'll start with our reciprocity applications. The first one is for cosmetology license from Nova Scotia, Canada for Zainab Barzagar. Documentation is provided, shows completion of cosmetology program and 1,500 hours received in 2002. No work history could be provided, and the recommendation is that he take the Tennessee examination.
Make the motion he take the Tennessee exam.
I second.
Motion made by Ms. McAllister and seconded by Ms. Walker Ali that he take the Tennessee exam following the board recommendation. All in favor, say aye.
Aye.
All opposed? Motion carries.
Application for reciprocity of cosmetology license from India for Ranjaven Chaudhary. Documentation provided shows completion of a program in 2004 with 1,900 hours received. No work history or license information was provided. Recommendations that the applicant take the Tennessee examination.
I make the motion that she takes the examination.
Second.
Motion made by Ms. Murray, seconded by Ms. McAllister that she take the Tennessee exam. All in favor, say aye.
Aye.
All opposed? Motion carries.
Application for reciprocity for Sonia Correa Camacho for esthetician license from Florida. Documentation obtained online from Florida verification system shows license as a facial specialist with initial license date of January 2010. Ms. Correa provided school information showing hours of 940 hours, with 900 received in Puerto Rico and 40 in Florida in 2004. Also included is a letter from Ms. Correa showing her work history. The recommendation is that the applicant be approved for reciprocal license.
Could I ask why you're recommending that she be approved based on what?
She does have a Florida license. We did it online ourselves. The Florida license that had been sent just missed us. In order to not wait till April, we're able on certain states to verify ourselves. The only downside to verifying ourselves online is we can't tell if they've tested or not online, but we can tell the license date and that it's in good standing. So she does have a current Florida license as an esthetician, and she shows 940 hours completed. So she's got the number of hours that we need, and more than that.
Her license, is this the one where the license is stated as a facial
Yes.
specialist?
Yes,
Okay.
the facial specialist.
Questions or discussion on this applicant?
I move that we approve per the recommendation.
A motion made by Ms. Walker Ali that we approve the recommendation that she get reciprocal license.
A second.
Seconded by Ms. Smith. All in favor say aye.
Aye.
All opposed, nay. Ayes carry.
Application for reciprocal license from Florida for natural hairstylist for Oleye Diallo. Certification shows initial license in June of 2013 with 16 hours. Ms. Diallo also provided a letter from Simplicity Hair Design where they state that she had hair braiding experience from 2001 through 2012. The license was not issued until 2013 and with just 16 hours. The recommendation is that she take the Tennessee examination.
Make the motion she take the Tennessee exam.
Second.
Motion made by Ms. McAllister, seconded by Ms. Smith that she take the Tennessee exam. All in favor say aye.
Aye.
All opposed? Motion carries.
Application for reciprocity of instructor license from Ohio for Donna Graves. Certification shows an initial date of licensure by examination in 1991 with 300 manicuring hours. The instructor license is issued based on salon work experience in Ohio, which is different from the Tennessee requirements. Provided are a letter from Ms. Graves explaining why her work history is not in the most recent 5 years. Also provided a letter from the Director of Education at Give Me a Hand School of Manicuring in Cleveland, Ohio, where Ms. Graves worked for 3 years, and also included is a personal resume. The recommendation is that she be approved for reciprocal license.
Make the motion to approve.
Second.
Motion made by Ms. McAllister, seconded by Ms. Murray, that we approve reciprocity. All in favor say aye.
Aye.
All opposed? Motion carries.
Application for reciprocity of esthetician license from Pennsylvania for Megan Hoxema. Certification shows initial licensure in October 2013 by examination. Hours required for aesthetics license is 300, and her record states she completed 450. The recommendation is that the applicant take the Tennessee examination. She has 450. Their requirement is 300, even though she has more, it's still not enough
Okay.
for us. And she just got her license in 2013.
Make the motion to take the Tennessee exam.
I second.
Motion made by Ms. McAllister, seconded by Ms. Walker Ali, that she take the Tennessee exam. All in favor say aye.
Aye.
Opposed? Motion carries.
Application for reciprocity of cosmetology license from New York for Sarah Jakowski. Certification shows full initial licensure in April 2009 by examination with 1,000 hours. Provided is a letter from Ms. Jakowski stating her work history between April 2008 and December 2010 at Bang Salon, and for the next year working independently until 2012 when she moved to Tennessee. She provided a letter for your review. The recommendation is that she be approved for reciprocal license.
Madam Chairman, I make a motion we comply with the recommendation.
Second.
Motion made by Ms. Smith, seconded by Ms. McAllister, that we approve the recommendation. All in favor say aye.
Aye.
All opposed? Ayes carried.
Recommendation, I'm sorry. Okay. Application for reciprocity of esthetician license from California for Larissa Mikuyak. Certification shows initial licensure is April 2012 by examination with 600 hours. The recommendation is that the applicant take the Tennessee examination.
Motion should take the Tennessee exam.
Second.
Motion made by Ms. McAllister, seconded by Ms. Smith, that she take the Tennessee exam. All in favor say aye.
Aye.
Opposed? Motion carries.
Application for reciprocity of cosmetologist license for Robin Colette Sitzler from Florida. Certification verifies licensure by examination and initial date in 1985 with 1,200 hours. Ms. Sitzler explained that she has work history, but not in the last 5 consecutive years. An email provided explains that she is interested in a manicurist license. She will correct her application and is really only requiring or asking for reciprocity for the manicurist license, not cosmetologist. The recommendation is that the applicant be approved for reciprocal license.
Make the motion should be approved for the reciprocal license.
I second.
Motion made by Ms. McAllister, seconded by Ms. Walker Ali, that she be approved for reciprocal license, the manicurist license. All in favor say aye.
Aye.
All opposed? Motion carries.
reciprocity of cosmetologist license from Florida for Velma Salzer-Varner. Certification shows initial licensure in November 2008 by examination with 1,200 hours. Ms. Salzer-Varner has not worked in the industry in the last 5 years, so no additional information was provided. The recommendation is that she take the Tennessee examination.
Chairman, I make a motion that you take the Tennessee exam.
Second.
Motion made by Ms. Smith and seconded by Ms. Murray that she take the Tennessee exam. All in favor, say aye.
Aye.
All opposed? Motion carries.
Application for reciprocity of cosmetology license from Florida, for Michael Welch. Certification shows initial licensure in 1979 by examination with 1,200 hours. Mr. Welch stated hours were received in Tennessee, but no license was ever issued, and the board records could not find that those hours were actually issued in Tennessee. No additional information is provided regarding work history. The recommendation is that he take the Tennessee examination.
Make the motion, take the Tennessee exam.
Second.
Motion made by Ms. McAllister, seconded by Ms. Walker Ali that he take the Tennessee exam. All in favor, say aye.
Aye.
All opposed? Motion carries.
Okay, on your iPads, we are on to the legal report that starts on page 77. I think Rob's plans, and he'll join us momentarily, is for you all to go ahead and review them like we did last time. It seems to go a little bit faster. Please make notes if you've got any questions with the recommendation, so that when you're done, if you can let me know, we'll address the changes to his recommendation or questions.
So you've done everything.
Y'all are reading, I just wanted to put your attention on page 91 of your pad, number 21, case number 21. That needs to be a civil penalty of $250, not $1,000. It's only one violation.
everybody. This is the facility administrator. We received notice from the parking coordinator, the state parking coordinator, that they're arranging right now for shuttles for people that are parked at the LP field. They're not sure exactly what the arrangements will be yet. As soon as they know that, we're going to get on the PA again and let you know. But the parking coordinator wanted to let us know that if anybody is parked at LP field, they are working out shuttle arrangements for that right now. And we'll let you know as soon as we have further information. Thank you.
They make us park at LP Field now, because they're building that baseball stadium in our parking lot.
Where is it?
The new sound stadium's right behind our building, right over here, so now the state employees park across the river. All the places in the whole city to put a baseball stadium.
It's gracious.
But I think they wanted to put it in Sulphur Dale. I think that's why they picked that. 34.
It's a 34, yeah.
It goes from page 77 to page 120.
No.
Please take your time.
Finished. Okay, I think everybody's looked them over, and do we have any questions?
I do have a question. I noticed with the consumer complaints, they were not fined for having unlicensed employees, but then in the violation cases, everybody was fined. So I'm not sure. It's number 2 and 5 in the consumer complaints.
That's because the ones that came from a notice of violation, we actually have the notice of violation, the evidence.
Okay, so it's hearsay?
Well,
so to speak, then?
potentially. I mean,
Okay.
if the board wants me to try to assess a penalty, I can.
I just wanted to know.
Okay.
Any other questions?
On number 13, this is a licensed cosmetologist whose license is suspended and was practicing on a client in an unlicensed shop. If the license were suspended, would that not be a violation?
Well, it's just, it's unlicensed practice. Has to be in good standing before he could use it.
Okay, any other questions?
Yes, on number 56. We had a formal hearing with the authority to settle for $2,000 on a civil I can't say it, civil penalty. Why don't we settle a $2,000 before we do the other and not let them stay in practice until it's...
This is probably almost certainly headed to a formal hearing, and we were going to combine the new one into one case and just add another. It says formal charges authorized, so it's already looking for a docket number.
Okay, any other questions?
Once again, I'll just remind you about number 21 that I overcharged. Because in reality, it's just one violation. I had $1,000 and it needs to be $250.
Okay, so that for sure is a change. Number 21 to 250. Anything else? Do I hear a motion?
I make a motion, Madam Chairman,
Which is what?
that we approve.
Okay, motion made by Mr. Herford that we approve the legal report.
I second.
Seconded by Ms. Walker Ali. All in favor say aye.
Aye.
All opposed? Motion carries.
Next on our business is are the consent orders for the month of February. We took in $1,500. We need a motion to approve those.
Move that we approve.
Second.
Motion made by Ms. Walker Ali and seconded by Ms. McAllister that we approve the consent orders. All in favor say aye.
Aye.
All opposed? Motion carries.
And we are going to wrap up in just a minute, I promise you. The next thing that I do want us to look at is next on your iPads, which is the information for the University of Memphis 2014 Instructor Seminar. It's to be held on June 8th and 9th. Provided is the seminar schedule, block description, and list of instructors. They're already on our website for those tentative dates. This would approve all their information for 2014. Seminar looks correct to you for the Memphis, then we need a motion to approve them.
There aren't any questions. I move that we approve.
Motion made by Ms. Walker Ali that we approve.
Second.
Seconded by Ms. McAllister. All in favor say aye.
Aye.
Opposed? Motion carries.
Due to the building closing of the builder, we're going to go ahead and wrap up. The items that I still have on your iPads are going to wait. We'll present them at the April meeting. The only thing I did want to point out, if you skim to the very end, the last thing on your iPad is the letter that the board voted on from Ms. Schlacher that we did last month. It's there for your review before we end. I would like you to take a look at it. That was emailed to her. Then the other thing is we handed you paper versions of the letters that went out to the Texas board and all the individuals that should receive what we talked about at the last meeting regarding the Texas allegations and Texas applicants. That's for you to take with you. That way you've got a copy of what was sent to them as well. If there are any questions, I'll be happy to either Rob or I to answer. Otherwise, I'm all done.
Can we have this letter that was drafted for the beauty bus? Could we have that emailed to us?
Oh, okay. Yes.
I was kind of looking for it. I thought maybe we might get it before the meeting today.
But okay. Absolutely. I will email that to you tomorrow, definitely.
Great. Any other business?
I just want to say that we missed June in this meeting, and Ms. Huckabee, and appreciate her service on the board for all those years.
Absolutely.
Okay, so if that's all, it's a tradition that the new board member adjourns the meeting, so if you would make a motion to adjourn.
Make a motion to adjourn.
Motion made by Ms. Barger that we adjourn this meeting. And is there a second?
Second.
Seconded by Ms. Smith. All in favor, say aye.
Aye.
Nays? Ayes carried. We're adjourned.
Ooh, goodness.
How fast can you make an iPad?
Yes.